Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and Andres. I'm joined by Christina Kuta, who is a member of our healthcare practice and real expert in everything healthcare. And today we want to talk about the number one question that we are receiving from clients, which is, are there non-competes anymore? Does the new FTC rule do away with them? And we want to answer your questions as best as we can at this point. So let's jump right in. And Christina, tell us a little bit about the FTC rule.
Hi, so the FTC rule establishes that as of the projected effective date of September 4th, 2024, non-competition provisions will no longer be enforceable for employees or contractors in the US with one limited exception. And when I say non-competition provisions, I mean generally mild restrictions. So a lot of, particularly in healthcare, employment or contractor agreements will say that once an agreement terminates, that for a period of time, the former contractor or former employee can't set up shop or compete with the business within a certain mileage area. The new FTC rule essentially says those are no longer enforceable. So as of September 4th, 2024, assuming that's the effective date, and we'll talk about that in a minute, you can't have any of those restrictions in an employment or contractor agreement. Also, as of that date, any prior non-competition provisions that were entered into in employment or contractor agreements are no longer enforceable, with one exception. If they were entered into prior to the effective date, with employees or contractors who are considered to be senior executives, meaning that they make at least $151,164 annually and are in policy-making decisions for the business, those may still be enforced. But as of the effective date, those will not be enforced moving forward if those senior executives are entering into non-competition provisions after that date. It's only for ones that have been entered into prior to that date.
Okay. So, and we're going to go into this in a lot more detail, but for those listening, right now, non-competes are, enforced and have guidelines on a state-by-state basis. So in some states, they have statutorily outlawed non-competes. In other states, they've put parameters around them. So for example, we're sitting in Illinois right now. You can certainly enforce a reasonable non-compete, and we have a statute that outlines the conditions for that. Person may have to earn a certain amount. They may have to be given certain notice to talk with a lawyer and have to be given some kind of consideration. And that's a pretty typical type of statute to be out there. So right now, really important, every state kind of does what they want to do. They have their own case law as to how to interpret this. So if the FTC rule was to go into effect, as Christina just described, it would purport to replace all these various state laws and supersede all the case law and statutes in these individual states. Okay, so let's talk about whether or not we think this FTC rule is going to go into effect.
So right now, there are a number of legal challenges to the rule and people trying to stop the rule from coming into effect. So I think that depending on those shake out, it's likely that we may see at least delayed enforcement pending some of these legal challenges. Additionally, this is an election year. So depending on who wins the election, this type of rule from the FTC might not be a priority. So it is possible that if a new administration comes in, that they may just pull the rule because it's not something that they find particularly important as part of their policy initiatives. So we are in a little bit of limbo there. Certainly we can't make any predictions, although I will say I would be surprised if it did go into effect in September just because of the amount of legal challenges right now.
Right. Now, but some of those legal challenges are whether the FTC even had the authority to do what it did and to, try and replace state law. States are considered to be independent in their lawmaking in certain areas, and this was definitely one of them. So I personally will be very surprised if this actually takes effect. And the reason I mention that is because, as you know, we work with doctors and dentists, and every single day when I'm talking to somebody about their contract, they tell me, oh, we don't need to worry about the non-compete anymore because it's not going to go into effect. And I say, I am not sure that's true. And even if I'm wrong, I'm pretty confident we'll probably at least see a delay. But here's the one thing I want to kind of have come out of that is you should still not sign a contract unless you think you can live with the non-compete that's in there, because we just don't know what is going to happen. So if you sign a contract thinking, oh, it's not going to be enforceable anyways, you may be very unpleasantly surprised. So my advice going forward is, even though we may not think it's going to take effect anytime soon or at all, any doctor or other healthcare provider signing a contract should sign it as if it will.
Absolutely. And I think that that's super important advice because we really don't know what's going to happen. It's a little bit of reading the tea leaves here. And on the flip side of that is we've also gotten a number of inquiries from people that are entering into non-competes related to non-employment or non-contractor agreements that are worried that they're not going to be enforceable. The FTC rule doesn't touch on those. So if you're buying or selling a business and a non-compete is important to you, that is not affected by the FTC rule at all. Also, even in employment agreements and contractor agreements, things like non-solicitation agreements, non-interference, non-disparagement, or non-disclosure are not impacted. Now, they may be impacted by state law, as you alluded to, Ericka. Illinois, for example, has laws on what you need to do notice-wise or consideration-wise to enforce those other type of restrictive covenants. But the FTC rule doesn't impact them at all.
What would you say about members of an LLC, like physicians who own a practice together? They have an operating agreement. Do we think that the non-compete provisions of that type of document will still stand? I would think those are senior executives. They're certainly, earning enough. What do you think?
Yeah, and also likely in policy decisions, just by virtue of the fact that they're owners. I also think that those aren't necessarily tied to employments or contractor services agreements. I would certainly argue they're tied to ownership, which I think might fall more in the bucket of like the sale of a business, as opposed to a true just employment or contractor arrangement. So a lot of times we'll have people that are members of an LLC, and the LLC operating agreement will have a non-competition provision, but then an employment agreement that those physician members also have has a non-competition provision. If the FTC rule went into effect and someone is hired as becomes a member and gets a new employment agreement after September 4th, we would know then that those employment agreement non-competition provisions wouldn't be effective. But I don't know that the FTC rule would actually necessarily implicate the ones that are in operating documents related just to true ownership. Although I would suspect we may have litigation on that at some point, because people will probably try to challenge on either side of what the tenor of that is. But it's not entirely clear at this point.
Right. And I guess one other thing is that you could still have loans or payments tied to restriction. So you're not calling it a non-compete and you're saying, hey, go ahead, you can do this, but it will cost X. And I think, the law is not super clear exactly how that would be viewed, since you're not saying somebody can't compete. You're just saying that, if you want to be in this area, you need to pay a certain amount and you're free to compete. So I think there's like a lot of nuances with this law where it's just not ready to go into effect. There's just so many things that we see every day in different contracts that really aren't even addressed in the proposed rule, that would leave so much uncertainty. that I certainly think we need clarification.
Yeah, and I think this rule disproportionately impacts healthcare because healthcare pretty universally has these non-compete provisions. And like, for example, what you just brought up with the loans, we have a lot of physician recruitment agreements. So those recruitment agreements might say as part of the employment agreements, we're not going to forgive your loan if you stay in a certain service area and work. Well, would the FTC rule say that that's a restriction tied to employment or engagement, or is that a restriction tied to, repayment of a financial obligation? Not something that's super common in other industries, not something the FTC really considered. And I think that, this is a little bit of a case of, I had a professor in law school who used to say, bad facts sometimes make bad law. And this might be a little bit of a case of this. I know that in the FTC hearings about this, there were a lot of people that came in and said that they had these non-competition provisions, but because of the work they do, they literally couldn't leave horrible jobs because they could in no way be able to go and get another job somewhere. And that's why they thought, these restrictions are not helpful and they really aren't good for the market. Is that really the case for a lot of people to have restrictions? Not necessarily, particularly in healthcare, depending on the area you work in, there's usually opportunities somewhere else to work. So I think it's a little bit over-inclusive and a broad law, and certainly will hopefully, if goes into effect, be pared down or have some more exceptions over time.
Right. I know many doctors say that they're totally anti non-compete, and I know they feel very strongly, especially, when they have hospital contracts with 25-mile radiuses. But the fact is that some restrictions on competition is not necessarily, in my opinion at least, a terrible thing. If you're a doctor that started a practice, have worked there for 20 years, you bring in somebody there, you introduce them to your referral sources, your patient, etc., and then they go and they set up right next door to you in the same building. There's something unfair about that. Now, if they have to go 2 blocks away, maybe that's better, So I think there's like so many nuances. It is not a black and white issue, very fact specific. And I don't think, it's fair to say you 100% support them or you 100% don't, because there are circumstances where I think they're entirely unfair, poorly written. I mean, think about hospital-based, anesthesiologists, radiologists saying they can't work within X number of miles. Sometimes it does, or hospitalists. I mean, sometimes it doesn't make sense at all, depending on what the type of medicine is, and they're not written well enough. But this is just, a rule that has not been refined enough, in my opinion, anyways, to go into effect. All right, so where do we go from here? What kind of advice are we giving people now about what to do?
So I say right now, we should still go with the status quo, meaning if you're a practice, let's say, and you're going to hire a physician, for example, tomorrow, I would still have the non-compete agreements. If you traditionally have them in your agreements, have the terms in there, meet the state law requirements and any other requirements that, you may have to meet to enforce that, with the understanding that, September 4th, it may not be enforceable. You may have to give notice to all your employees on that date that says, we are no longer allowed to enforce these non-competes, which is part of the FTC rule, actually. There is a notice requirement. But because we don't know when it's going to go into effect necessarily, the extent what it may look like if it eventually does go into effect, if it's modified in some way,
Right.
I think right now it's status quo until we have a little bit more certainty on, whether it actually becomes effective on September.
And I guess what I would say is also make sure that you don't just have a geographic non-compete. You want to make sure that you have, very full and complete non-solicit, confidentiality, non-disparagement, non-interference, so that if one piece of it drops out, you can still fully use the remainder. If you don't have liquidated damages tied to a non-compete because there's still a lack of clarity on that point, maybe that's something you might want to consider adding in. And the one other thing I'll say also is make sure you have a provision in your agreement that severs a provision and allows the remaining contract to remain in place. So if the court was to say any non-competes do not apply, we don't want the whole contract terminated. We just want that one provision. So there is some rethinking. I know the ones we do have everything in it that I've just mentioned, but I review a lot of contracts that sometimes they only have a geographic non-compete. And in my mind, those people really need to, or those owners need to make sure that their contracts are improved.
Definitely. Right? If you haven't looked at your non-compete in a while and your term agreements, now is probably the time to do so, to make sure it's as robust as possible related to at least those non-competition provisions you mentioned. Make sure there's the severability language in there, and just sort of, revisit what it looks like in anticipation of maybe this change happening would be a good idea.
Right. And one other thing I'll mention is, don't assume that the word non-compete everywhere in your corporate documents is going to disappear. One question that I've received is a lot of times in our practice documents, the severance pay might be tied to the departing owner's compliance with the non-compete. So they're not going to continue to get paid if they violate the non-compete. Now, that is money tied to non-compete compliance of a departing shareholder or member. So we still don't have enough clarity to know if that's treated differently than just an employee leaving, but I suspect that it might. So before you assume that you can't enforce anything, or that all the situations when you can and you can't, or that you need to advise your employees certain sections don't apply anymore, make sure you talk with counsel. And some of this is going to lead to some very interesting disputes and case law, I think, unless, we get some real clarity here.
Definitely. I think if one positive came out of this, it's that the, employee litigators bar is probably going to, employment litigators bar are going to have a number of opportunities to litigate some of these issues and try to get down to exactly what's prohibited.
Right. And I can definitely tell you that we've already started to receive letters from people saying that, an employee can leave because the FTC came out with that rule. And I'm not buying into that. And nobody sending me that letter is getting away with getting out of a non-compete at this point, because we don't know that it's going into effect or not. And it's a little premature. So timing is everything as well. And I think we all just need to sit tight. And please, if you're a doctor listening to this, you can assure your colleagues that, this is not a clear situation. So please, again, don't sign something with a non-compete in it unless you plan to comply. You cannot be certain that you will be getting out of it. So I really am worried about getting some calls about people who signed non-competes that they didn't think they had to worry about, and they do.
Yeah, we do hear a lot of people say, "Oh, it's not enforceable anyway." That's just not true. So be mindful.
That's right. All right. Well, if anybody has any questions about this FTC rule, about their own contracts, their non-compete language, improving their non-compete language, feel free to reach out to Christina Kuta or myself, Ericka Adler. We are both at Roetzel and Andrus, and you can reach out anytime. And this has been the Health Law Hotspot. You can see more of the episodes we've done at ralaw.com, and we hope to see you next time. Thanks.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.